Welcome to this webinar from McGrath Sheldrick on UK immigration and Tier 2 sponsor licenses. This is a part of a series of webinars that we're presenting on immigration issues for the UK, for the US, and also global immigration issues. And in particular, we're going to look at the rules and criteria that apply to employers, workers, investors, entrepreneurs, and family members coming to live and work in the UK. In this instance, we're going to be looking particularly at the situation for employers who want to sponsor foreign citizens to come here to work. And we're also going to be looking ahead to 2021, when the new schemes will be introduced as part of the new framework for immigration control that will come in as planned, we understand, on the 1st of January next year at the end of the Brexit transition period. So just to introduce my colleagues, I have with me Joanne Taylor, who's one of our partners. Are you there, Jo?
Hi, Ben. Yeah.
I say I have with me. She's at home at the moment, as everybody is at McGrath. And also Davina Fernandez, who's one of our senior associates. Hi, Davina.
Hello.
So we're going to split this up between us. The idea of this session, if we just move to the next slide and we look at the discussion points, we're going to be, in a sense, going back to basics for employers and looking at the UK sponsorship regime. In particular, we're going to ask what is a sponsor license, the importance of the sponsor license, essentially, as it devolves responsibility for immigration controls to employers. It gives them freedom to sponsor foreign nationals, but at the same time, it imposes a lot of obligations and duties on them. Who can we sponsor now? Foreign nationals outside the European Economic Area, and then we need to think about next year when the situation changes and the UK is no longer part of the single market. And then how do you apply for a sponsor license? Just looking at the practical steps, the requirements, some of the hurdles that may be in the way of obtaining the license, and then what are the obligations you can expect once you have a sponsor license in terms of record keeping, reporting obligations, and being ready for audits that may occur if the Home Office comes knocking at your door. So if we go to the next slide and just ask Joanne, Jo, what is a sponsor license?
Sure. So we're dealing specifically in the context of Tier 2 today. So Tier 2 is the route that enables UK-based employers to employ workers who would otherwise not be permitted to work in the country, so in the UK. Currently, EEA migrants, EU plus Iceland, Liechtenstein and Norway and Switzerland benefit from free movement. So currently not covered under the Tier 2 scheme at the moment. Tier 2 enables employers to source talent from outside the labour market. And once granted, a sponsor licence is electronic, so you go to a web portal to access it. The web portal is called the Sponsor Management System. It enables you to assign what's called certificates of sponsorship to individuals, and those certificates have personal details and information about the job that they're going to be doing in the UK. And those individuals will need to be skilled. So they can either be new hires to the organisation or transfers from an overseas entity called intra-company transfers. The licence itself lasts for 4 years and comes with a number of compliance obligations, which I think we'll probably discuss later because it is important that people understand what those are.
Sure. And so this is the scheme that we have now.
Yeah.
Do we think that it's going to stay in place after the end of this year?
Yeah, I mean, we think so. We expect it to be expanded to encompass the EEA and non-EEA nationals all into one single licence. We don't expect any major changes to the infrastructure of the sponsor licence, so it will still be the same portal. But we do anticipate some changes to the criteria, such as salary levels, and taking away that requirement to advertise roles as we come out of Europe.
Okay. So yeah, let's have a look at the advertising requirement a little bit later on. So if we just go to the next slide, and Davina, tell us who can we sponsor at the moment?
Well, at the moment, you can sponsor any non-EEA nationals who will be coming to the UK to do a skilled job. The Home Office want to see that the role is graduate level or above. This doesn't mean that the sponsored worker has to have a degree, but the job that they're going to do has to be pitched at this level. So occupations such as doctors, nurses, engineers, software developers, IT professionals, business analysts, jobs in the financial sector, marketing, advertising, business development, they all feature on this list. Your more senior directors and managers will also tend to qualify. So if you do want to sponsor for a role, the first step would really be to look at the job description and to look to match it against one of the roles on the SOC code. The most appropriate SOC code will be the one which contains the job description that best matches the role to be performed. So if you're able to do this, then the next step will be to look at the minimum salary that you'd need to pay. To qualify for Tier 2 sponsorship, the worker will need to be paid either the minimum salary for Tier 2 sponsorship, which is 30,000 for Tier 2 general, or
so 30,000 is the current is the salary level now for sponsorship.
That's correct. Yeah, for Tier 2 generals, but it's 41,500 for if you want to sponsor under Tier 2 intra-company transfer. So it's either that minimum salary or the appropriate rate for the job in the chosen SOC code, whichever is higher. All the codes will have different rates, which will be appropriate for the particular occupation. And so the appropriate rate will effectively be set out in the codes. What you're looking at, is it the minimum threshold of 30,000 or 41,500, or is it, you know, what's on the SOC code? You have to go with whichever is higher.
Okay, and you mentioned in your third point there about the RLMT, which is the Resident Labour Market Test, isn't it? Can you just very briefly tell us what exactly that is?
Yeah, it's effectively the Home Office's way of ensuring you check there's no suitable set of worker able to do that job before you offer sponsorship. To meet their requirements, you'd need to advertise the job you want to recruit in 2 approved sources for 28 days. So it could be a newspaper or online sort of recruiting portals such as Find a Job, for instance. If you've not been able to identify any suitable set of worker from your search, you know, someone who meets all of the skills, qualifications, and experience that you've sort of requested in your advert, then you'll be able to sponsor that Tier 2 worker, and you'll have met your resident labour market test requirements. Okay,
and then you also mentioned English language. So I guess for many countries that won't be a problem, America or Australia, New Zealand, etc. Right. But for a lot of people around the world, it will be. How's that established?
Well, effectively, as you pointed out, there's one way of meeting it, and that's because you're, you know, you're from a country where English is the majority language, so Australia, Canada, US. Otherwise, if you hold an acceptable degree level qualification that was taught in English, you'd be able to use that to meet the requirement, or alternatively, you just need to take an approved English language test.
Okay, brilliant. And then let's just move on then to the next slide. Also on the topic of who we can sponsor. Jo, did you want to expand on this one?
Yeah, so it's important. Obviously, January 2021 isn't hugely far away, so we should look forward to how this scheme may be expanded next year. And what we can expect is this new points-based immigration system. So we're looking at an expansion to the current Tier 2 framework that allows for more roles to be included under the Tier 2 sponsorship. So codes will be expanded to include RQF level 3 roles. So that's essentially A level and above roles. It is fair to say that this is still, you know, quite a matter of contention at the moment in light of the current pandemic. There's much discussion about what roles may well be included, certainly around lower skilled roles under RQF level 3 and how they may be catered for. So I would say watch this space. And then obviously we're looking at a salary requirement, but a lower one. So where Davina was talking about £30,000 for a Tier 2 general, the new likely salary threshold will be 25,600 according to the policy statement so far. And then looking at, as we've already said, about abolishing kind of resident labour market testing for for those people, but it is important to keep in mind that English language will probably be important for European nationals going forward under Tier 2 General, because they'll all need to meet that requirement.
Yeah, that's a really good point. And they obviously will not be coming from primarily English-speaking countries, and
No.
they very well not have done degrees that were taught in English either.
Yeah.
Okay, and then so the key determining feature in the new scheme as it's currently planned will be salary, because they're abolishing the resident labour market test, as you said, but potentially lowering the salary threshold to 25,600. And it's a good point that you make also about whether that's the right threshold. Obviously, at the moment, as we're recording this webinar, there's a lot of discussion around what constitutes skill. Recognizing the fact that people working in the NHS in particular are providing very important functions to the country, but may not potentially be earning £25,600 a year. So that's a really hot political discussion at the moment. The only other point I would make, we've got an immigration bill going through Parliament at the moment, and that within that bill is provision for protecting Irish citizens in the future, so that they do not have to be sponsored. They effectively retain rights of free movement into the UK and the right to work here by virtue of our long-standing relationship with Ireland. So that's one good piece of news for Irish citizens. So let's just go on to the next slide and talk about the categories under Tier 2. Who's going to kick off?
So there's two categories that you can sponsor under the Tier 2 General, which is typically for sort of new employees, new hires, who'd like to come into the UK on a more permanent basis. And this is because the Tier 2 General, there is a route to settlement. So after a period of 5 years in this category, for instance, you'd be eligible to apply for indefinite leave to remain. With Tier 2 General, though, you're capped at 6 years. So that's the maximum period at which you could hold a Tier 2 General visa, which is the reason they give you that opportunity to apply for indefinite leave to remain at the 5-year mark, or after you've been here continuously for 5 years. With the Tier 2 General, there is a resident labour market requirement currently, and also an English language requirement, and your minimum level of salary is going to be 30,000 or whatever the code of practice says. And then you've got the Tier 2 ICT, sort of the long-term or the graduate trainee category that you could also use. Jo, did you talk a little bit about?
So for the intercompany transfer route, so the key to these is really that you've had some sort of previous employment overseas with your sponsor before coming to the UK. So under the long-term category, it's usually around the 12 months, unless your salary is over 73,900 in the UK. And under the graduate trainee, you'd be looking at 3 months previous employment outside of the UK. Both of these categories are temporary, so you wouldn't use these for anyone coming to the UK on a more permanent basis. If you wanted them to come here and get indefinite leave to remain or settlement, you would look at the Tier 2 General route. But this can be useful as they're usually much quicker to get visas under these categories. So you haven't got the resident labour market test, which can take time. There's no cap on the numbers that you can bring in. And there's also no English language requirement. So it means that if you've got to do an English language test, that may slow a process down. So if you need key people in the UK quickly and they're working for you abroad, then this may be an appropriate category. It's probably going to lose some of its shine after January 2021, but it may still be useful for those who perhaps are struggling on the English language requirement going forward. Slightly higher salary levels for the long-term category than the Tier 2 General, but still quite a widely used category in the UK.
Okay. Yeah, and I can't remember, I don't think I've seen anything in the policy statements for the future around the salary threshold for intracompany transfer from next year, because it's set quite high under the current regime at 41,500. So that'll be interesting to see, although
Definitely.
you make a good point that it may not be necessary to use that route because the resident labour market test is going anyway. So we'll just have to watch that space. And then the immigration rules talk about cooling off periods, don't they, for people who've been here under Tier 2? What exactly does that mean?
Sure. So the cooling off period is essentially a 12-month period where you can't be in the UK with a Tier 2 visa. So you leave the UK and you'll have to serve 12 months outside before you can come back on another Tier 2 visa. So you can come back on other routes. So as a visitor, if you need to visit for business purposes, for example, but you can't hold a Tier 2 visa during that period. There are a few exceptions to the rules. So high earners, for example, those earning over 159,600 don't have to wait a 12-month period. And also, if you bring someone in for a really short period of time, for example, you give them a certificate of sponsorship for less than 3 months, again, that's another way that they don't have to serve a 12-month cooling off period. But essentially, once you have your Tier 2 visa and you leave the UK, you have to wait 12 months before getting another one. So it stops people from getting continuous Tier 2 visas but never settle in or kind of going through the traditional routes.
Okay, thank you. So as we head towards 2021, many more employers are going to want to think about the sponsorship scheme because EU citizens will be captured by the immigration rules in ways that they were not before. So if we just go to the next slide and talk about how to apply for a license, what are the basic requirements for the application?
So there's a few stages. I mean, the first thing you need to do is to complete an online application. And then shortly after submitting that, well, within 5 working days, you need to submit your supporting documentation as well. In some cases, the Home Office will visit an organisation so that they can be sure that that specific organisation is going to be able to meet their obligations as a sponsor. And thereafter, they'll make a decision as to whether or not to grant a license. Applications tend to be processed within 8 to 12 weeks, dependent on demand. It's likely to take a bit longer if the Home Office decide that they'd like to visit or audit you before they make a decision on the application.
Okay, sorry.
No, I was just going to say, I think given the new regime next year in 2021, it makes sense because of the demand that we're expecting that you look to apply for a sponsor license earlier to take into consideration all these delays. And just so that you're going to be effectively able to employ people or start using the new system in the new year. Okay,
then so very briefly, what kind of documents do you need to send with an application in order to get it through the Home Office?
The documents that they request are really the type that will show that a business is actively trading in the UK. So things like bank statements, VAT registration certificates, evidence of registration with HMRC, employers' liability insurance, leases, things that businesses will already have, but which show that they're actively trading in the UK.
Okay, and you mentioned visits from the Home Office and audits. What can you expect to happen at an audit? Maybe we should just go to the next slide for that.
Yeah. If the Home Office decide to visit, they're going to be looking at your processes effectively to make an assessment as to whether you have the necessary HR systems and procedures in place so that if you are licensed, you'll be able to carry out your sponsor duties effectively. They'll also be looking to verify that the information you've given on your sponsor license application is accurate, that you're genuinely going to be able to offer employment that meets the Tier 2 requirements and pay the correct skill, the correct pay level as well. And they also will want to see that you're complying with your obligation to prevent illegal working. In terms of an audit itself, what they tend to do is to ask a series of questions to get the information that they need. But they can also ask you to demonstrate how your systems work and are likely also to ask to look at some of your personnel files so that they can look to see that you're undertaking legal right to work checks as part of your general obligations.
Okay, and how often should we expect an audit if we get a sponsor license?
these tend to be random, although we have noticed that they tend to audit at the license renewal stage, and audits can be announced or unannounced.
Okay, and then if we fail the audit, what are the sanctions?
Well, if you've already got a license, if you haven't already got a license, the application will be refused. But if you do have a license, they'll consider, because these audits can occur even after you've been sort of granted a license. So if they come to you afterwards, they're going to look at the nature of any suspected breach and take action accordingly. So what they could look to do is to downgrade your license, so that will limit the number of certificates of sponsorship you're able to assign. They could look to suspend your license, in which case you're not going to be able to assign any certificates while they deal with your suspension. And, you know, the most damaging, I suppose, is that they'd look to revoke your license. And that means that you just can't use the sponsorship route anymore. And everyone that you do have sponsored in the UK, their leave will be curtailed and so on. And then you're prohibited from applying for another sponsor license for at least 12 months. So there are consequences with not, you know, playing by their rules.
Yeah, those consequences are pretty serious, I guess. If you have a license and you've got a number of people working for you here in the UK, you have the potential to lose not only the license, but for them to lose their permission to be here, that's a very serious, that would have a really serious impact, wouldn't it? Okay, best to avoid that then. So if we just talk about going back to the license itself, if we talk about the key personnel, because there are individuals with particular duties and obligations to the Home Office. So on the next slide, if we just look, I think that's it.
Yeah.
Jo, did you want to talk about this?
Yeah. So I've put this as a pyramid with the authorising officer at the top. So this is your most important role that you're going to fill, and you may not have come across this, title or anything before. So you must appoint an authorising officer when you apply for the licence, and the person you nominate is going to be your most senior person in charge of the recruitment of any sponsored workers, and they also will be the ones responsible for ensuring that all your sponsor duties are met. You've got to have an authorising officer throughout the whole duration of the licence, so you can't, if they leave, you have to make sure you replace them. And they will also determine who has access to the licence and how it's operated. So it is a very important role, and it's important that they understand what it entails. Then we go on to the key contact. So this is usually the person who acts as the main contact between the Home Office and the sponsor, so you. The Home Office would usually contact the key contact with licence renewals, or restricted certificates when they come through, things like that. Or if they really need to get hold of the sponsor, they may contact both the authorising officer and the key contact. For this reason, we probably recommend having different people so that you make sure that any correspondence isn't missed. You can have a legal representative fill this role as well, so it doesn't have to necessarily be someone within your organisation. Then while we're talking about representatives, you can have a representative on your licence who can assist you with everything in relation to the licence. So we act as legal reps for many organisations, and being named on the licence means that we can contact the Home Office on your behalf and liaise with them, and also be a level 1 user, which I've kind of got on there as well. So level 1 and level 2 users. So level 1 users are people on the sponsor management system that have full access to it. They can report organisational changes, they can assign certificates of sponsorship to any individuals, they can make reports against any individuals in terms of the end of sponsorship or any changes to their sponsorship. So they have full access. There has to be at least one person from within the organisation who is a level 1 user, so that they always would be on the licence and can make changes. But in addition to that, you can have your legal representatives as well as a level 1 user. And then you've got level 2 users, which have more limited access. So they can only see certificates that they've assigned, and they can only make changes to those. There's no organisational changes that they can make on the system. So it's important as you go through the licence that you understand these personnel on the licence, and that you fill them appropriately with the right people within the organisation.
Sure. Okay. So the authorising officer has to be from the organisation, and that person has a lot of ultimate responsibility.
Yeah.
But all of the other categories can be undertaken by representatives if the employer wishes to do that.
Yeah. Apart from having one level 1 user, which may well be the authorising officer as well, everything else can pretty much be dealt with by legal representatives if that's easiest.
Okay. And then just moving on to the next slide, we're talking about obligations. So this is all around ongoing record keeping, etc., in case we have one of these famous audits. So what are our obligations?
Sure. So essentially, if you get a license, my best tip for anyone is to download the document called Appendix D. So that is your Bible as to what documents you should keep to meet your sponsorship requirements. So there are all kinds of documents that's listed in there that you should keep, and they include evidence of your legal right to work checks, and they should be conducted on all employees, not just your sponsored employees. Any documents relating to sponsored workers, so that might be your evidence of your resident labour market test, contact information, contracts of employment, job descriptions, national insurance numbers, salary, wage slips, things like that. And then company documents as well. So copy of your sponsor licence application and any documents you submitted to support the application. So as Davina was talking about, those documents that you get together and send to the Home Office, keep a copy of those as well.
And where do we keep them? Do we have to keep physical hard copies, or can we keep electronic copies?
No, so the key is that the records are kept somewhere that is accessible in the event of an audit. So as long as you can access them at short notice, if necessary, that's the key. It's absolutely fine to keep them electronically, and often it's easier on a document management system or a HR system to retain your documents electronically, and then it will also enable you to get hold of them at any time, even if, as we all are now working from home, if you needed to provide them to the government or HMRC or the Home Office, then you can do that. So it's probably recommended that you keep them in some form as well electronically if you do have hard copy.
And how long do we have to keep? I suppose if we've got a license on an ongoing basis, then we just have to keep them, keep the documents on an ongoing basis.
Yeah. So usually you should keep documents for the period that you sponsor them and for a year afterwards. But there's also this caveat that you should also keep them until a compliance officer has examined and approved them. But that's usually if it's less than a year after they've stopped working for you. So if you have a compliance officer and a visit 6 months after someone stops working for you and they view those documents, you can then get rid of them. The only thing I would say is legal right to work documents is slightly different. So everything else in relation to your sponsored workers is for while they're sponsored and a year later, but all your legal right to work checks you should retain for the duration of their employment and a further 2 years afterwards. So it's just important that you keep those separately and you keep them for the right amount of time. Okay,
that's really helpful. And then in terms of reporting, etc., I think we've got the next slide talks about reporting and monitoring. Davina, do you want to just run us through these?
Sure. So there's 2 sets of events that you need to report against if there are any changes to your organisation. So that's changes to the address, the name, the key personnel, the size of your business. You need to report that to the Home Office. But then also anything relating to any of your sponsored workers. So changes to their start date, the contract, job duties, working hours, all of that needs to be reported, usually through the sponsorship management system.
Okay. And how long do they give us before we have to make a report if something happens that triggers that requirement?
Yeah, it really depends on the type of report you're making. So if it's in relation to specific sponsored workers, so the changes to job duties, salary, etc., those reports need to be made within 10 working days of the change occurring. But if it's in relation to an organizational change, things like change of name and address, you need to do that as soon as possible. Other reports such as mergers, changes to structure, etc., those need to be done within 20 working days.
Okay, and I suppose an employer may take somebody on for, I don't know, 3 years or 5 years, whatever it may be, and that person may leave earlier than expected. What do we do then?
Well, if an employee leaves, you need to report this to the Home Office within 10 working days of their last date of employment through the sponsorship management system. Once this gets processed, the Home Office will then write to the employee to let them know that their leave or their visa is going to be curtailed within 60 days of their letter. So the employee then has that time to, switch immigration category or to find another sponsor who's going to be able to sponsor them. Or if they're unable to do that, then that's their time limit to leave the UK.
Okay, so there's quite a lot to unpack there and to remember. So just on the next slide, I think that is everything we're going to cover just for now. The aim of these webinars is to provide overviews of the various obligations and requirements and systems that are in place, but obviously we can provide much more detailed information and guidance and answer questions that are more complicated, etc. But hopefully that has been useful. Do get in touch with us if you would like to. You'll see our contact details there, our email addresses and our telephone numbers. So any questions you've got, just send us an email, get in touch, and we'll be very happy to help you. And that's it for now. This is the end of this webinar. We look forward to the next one, hopefully next week. Thank you.
Great, thank you.